Mr. Knox.
My Lords, before I go back to George's judgment, can I just mention three things that arose out of this morning's discussion? First, it is Section 40 of the Constitution which provides for the amount of senators who can be appointed respectively by on the advice of the Prime Minister, the opposition, and himself. My Lord will provide as far as Scene 9 is concerned, the relevant passage in which the Court of Appeal says there isn't an inherent jurisdiction in relation to bail to grant a bail for murder post-conviction is 1601 to 1602. I can just go to that. After reciting the effect of 48.1 and 48.2 of the Supreme Court of Judicature Act, they conclude, the majority concludes, and I think the minority agreed with this, at the foot of the page, when the two sections in question are construed together, they regulate two clear situations. One, how the convicted person is to be treated and accordingly dealt with by the prison authorities under the prison rules, pending determination of the appeal. And two, the machinery for computing the period of actual imprisonment or labour that the convicted person must serve according to whether or not he had been granted bail pending the determination of his appeal and didn't succeed eventually on his appeal. Then they say there's lots of support for that approach from English and West Indian cases. In my opinion, the legislative policy with regard to persons involved in the commission of offences for which the penalty fixed by law is death is clear. Once that person is committed for trial, he's not entitled to bail. If convicted, whether he appeals against his conviction or not, he is by the provisions of the prison rules in a different category, and as such also treated and dealt with differently from those convicted of an offence for which the penalty does not involve the possible deprivation of life, as distinct from a deprivation which is limited only to the possibility of a deprivation of his personal and physical freedom for some period. Another distinction in the policy is in its stringency of treatment towards the two, which in my view is notable and significant, lies in the fact that whereas a person who's convicted of a non-capital offence may, in the discretion of the court, be granted an extension of time if he files his appeal against conviction or sentence outside the statutory limitation, the court has no discretion to do so for persons convicted of an offence for which the sentence is a mandatory sentence of death. And that's how the Court of Appeal approached the point in relation to post-bail convictions in a case of murder. And they go on to deal with various other submissions about the absence of records and so forth in halfway down, 1602. The other point was put to me this morning, well, what about the hard cases? Let's say a person has been committed for trial, whether under the old regime or the new regime, and then new evidence comes up which shows that in truth he couldn't have, very unlikely to have committed the offence, but one can't get to court in time for an actual discharge or for the court to determine the matter. Could bail be granted pending such an application being heard by the court? My Lords, the immediate answer which has occurred to Mr. Hussain and myself is that if, in such a case, it was obvious that the great hardship was being sustained by an individual by reason of a court order that has already been made, because, let us say, is working great injustice or infringing monetary rights, it would be possible then to go back to court by way of constitutional motion and say that it is, in the particular circumstances of the case, an unlawful deprivation of your freedom or liberty, or maybe cruel and unusual punishment, to keep you in jail pending your application to be discharged from committal, when there is a clear case that you ought to be discharged in any event. My Lords, that may be the answer. In other words, the Constitution, if there is great hardship, if, let's say, a statute, for instance, Section 4 of the Offence Against Person, works in a particular circumstance, great hardship, once the sentence has been imposed and once the order has been made, then the answer may simply be that if it is simply unreasonable, completely unreasonable, contrary to human rights, that you should be kept inside, pending your application to be discharged, then the answer would be you go by way of constitutional motion for an immediate discharge. My Lords, whether in fact the DPP would have a power himself to say, without a court order, I'm going to let you out, my Lords, I don't know. But, my Lords, we do say, however one approaches this, one can always come up with extraordinary cases and say, well, what's the position there? To which our answer broadly is, and we'll have to think about this more, our answer is broadly, there are ways, and the Constitution does allow for this under Section 14, of avoiding what effectively would be cruel and unusual punishment or unlawful deprivation of liberty. But that doesn't of itself mean, and that can coexist with the scheme of the Bail Act, or indeed the previous scheme. And one simple way of looking at it is the Bail Act itself doesn't even contemplate what would happen in such a situation.
Well, it prohibits bail, full stop.
Well, it prohibits the grant of bail in a case of murder.
Yes.
The question would be, what if? But I mean, in one sense, it's a bit like the mandatory death sentence. It requires the sentence to be carried out, but then events take place subsequent to that, and it becomes unlawful for that sentence to be carried into effect, which can show that the cruel and unusual for to be carried into effect. And that would be the analogy. There comes a point where a lawful order of the court, lawfully made at the time, one can say that a particular circumstance had arisen, which would entitle you to say the continuation of the circumstances amounts to cruel and unusual treatment and unlawful deprivation of liberty. You go back to on that basis.
But it wouldn't be bail that was being granted then. It would be
bail as such. No.
It would be an accelerated discharge or something of that nature.
Yes, you can be asking for constitutional relief, and it may be asking for interim constitutional relief pending a final examination of the application. But in my submission, the Constitution wouldn't prevent that application being made in those types of circumstances, either before or after the Bail Act 1994. My Lords, I submit one has to be careful not to make the Bail Act, if I can put it this way, so unreasonable as to make it easy to challenge under the Constitution. But one has to read it as passed under the Constitution, and therefore not as intended to exclude constitutional rights and remedies which might arise in extreme cases, which obviously the legislature didn't foresee at the time, and especially changing circumstances. My Lords, if I can go back to Robinson and Seeley, I think I was at page 32.
So what page, sorry?
32. It's just the first paragraph on 3032, my Lords, just makes the point in fairly forceful terms that one has to be careful not to treat laws passed under Section 13 in the same way as one might be looking at laws passed under other constitutions which have not been passed under Section 13. In other words, it emphasises the point that you presume that it is taken as read that there has been or will be an infringement of the rights, and the whole question must be looked at in the light of that to see whether it was reasonably justifiable.
Could you please just give me the EF?
3032, first paragraph.
The electronic bundle.
Oh, it's page 3032 at the top of the page.
Right. 3032.
Sorry, 30, sorry.
3032.
Thank you.
In particular, but it draws a contrast, and I submit this is a valid contrast with considering when looking at decisions from other jurisdictions which don't have this notion of an actual constitutional override of fundamental rights. That's the first paragraph. And then the third paragraph, it's the point which I mentioned before lunch, which is in Section 40 of the Constitution. The burden of showing the act is not reasonably justifiable can only rest on those who challenge it, not on those who set it up. The scheme of the legislation seems to me also to support that interpretation. Although fundamental rights and freedoms are guaranteed and enshrined, the constitution makers appear to have envisaged that the need might arise to interfere with them in the interest of the community as a whole. Power to do this is vested by Section 5, but a special majority is required to ensure that the interference will not likely be embarked upon. The 3/5 majority required in each House ensures that a bill for such an act cannot be passed into law if the senators nominated by the Governor on the advice of the Prime Minister alone vote for it. In other words, if only 16 out of 31 vote for it, it won't get through. At least 2 senators appointed on the advice of the leader of the minister of the opposition or on the advice of the Prime Minister after he's consulted such religious, economic or social bodies or associations from which he thinks such senators should be selected must support such a measure before it becomes law. To ensure, however, the basic structure of the society is one in which the rights of the individual are respected, is not altered, the proviso is inserted. I emphasise basic structure. Such a law can be challenged on the law that it's not justifiable in such a society which has a proper regard for the rights of the individual, and so forth. And then at page 34, the judge turns to the particular act in question. In the absence of extrinsic evidence, the 1972 Act must itself be examined to discover whether it contains features which can be shown not to be reasonably justifiable, and so forth. Although propounded for purposes which seem to me to be different, I would adopt the principles propounded in State of Madras v. V.G. Rowe, SCR, I think, an Indian Supreme Court decision, as useful guidelines in determining whether legislation passed under Section 5 has been shown not to be justifiable in a society which has proper respect for the rights of the individual. Speaking for the court, Pantayali Shastri, CJ, said, the court should consider not only factors such as the duration and extent of the restrictions, but also the circumstances under which and the manner in which their imposition has been authorised. The nature of the right alleged to have been infringed, the underlying purpose of the restrictions imposed, the extent and urgency of the evil sought to be remedied thereby, the disproportion of the impositions, the prevailing conditions at the time, should all enter into the judicial verdict. In evaluating such elusive factors and forming their own conception of what is reasonable in all the circumstances of a given case, it is inevitable that the social philosophy and the scale of values of the judges participating in the decision should play an important part, and the limit to their interference with legislative judgment in such cases can only be dictated by their sense of responsibility and self-restraint, and the sobering reflection that the Constitution is meant not only for people of one way of thinking, but for all, and that the majority of the elected representatives of the people have, in authorising the imposition or restrictions, considered them to be reasonable. And I submit that is actually the proper approach. You look at everything, but you've got to be, obviously you consider what Parliament's concerns were, and the judges themselves have to be rather cautious in this exercise, so they themselves aren't seen to be replacing the democratically elected politicians. And the judge continues, the final sentences of that quotation are particularly applicable to the situation in Trinidad and Tobago, since the Constitution specifically gives to Parliament the power to override fundamental rights and freedoms, and the prescribed procedure for so doing makes it necessary that Parliament should quite consciously state that it has done so. Using this approach, I shall now consider the criticisms aimed at the Act, and so forth. My Lords, can I just add this? It's an obvious point, but it's not just the Act itself which has to have the relevant preamble about interference with fundamental rights and freedoms, and it's being passed under Section 13. The bill has to have it as well. So everyone knows what they're doing when they are voting on these things. It doesn't just sort of turn up afterwards because sufficient majority has been obtained. Everyone has to know in advance that that's what they're doing. The judge then goes on to consider this point against the facts of the case. And if I can go to 36, I think. Second paragraph. The core of the challenge to the Act appears to me to lie in the third objection, that the method of control vests the discretion to grant or withhold permission to march in the Commissioner of Police, and does not lay down adequate guidelines as to the factors which should be considered in the exercise of this discretion. I agree that the Act lays down no such discretion. He then goes on to consider a similar type of Act which had been passed in St Kitts and how that had been dealt with, I think, by the Privy Council. I'll come back to that in a moment, if I may. But then over the page, having discussed that particular challenge, Mr. Justice Telford George's refers to a decision of the Privy Council on an equivalent St Kitts provision, which was not a Section 13 provision, but just a general provision, which was challenged for being unconstitutional. You'll see at the top of 3038. Lord Pearson stated, the final question is whether Section 5 of the 1969 Act is so defective as to be unconstitutional because it doesn't expressly lay down guidelines for the exercise by the Chief of Police of his licensing power. Whether or not it might have been better to have some express provision as to the way the discretion should be exercised, he is not without guidance. It's plain from the preamble to the 1969 Act as a whole that his object is to facilitate the preservation of order. That being the object of the Act, he must exercise his powers bona fide. And then he continues, Section 5 is not defective, or at any rate not seriously defective in this respect. So, in a sense, a test of is it seriously defective, not just I can make some criticisms. This criterion of serious defectiveness seems to me appropriate as one in deciding the issue as to whether an enactment contravenes a provision such as Section 11 of St Kitts Constitution, which has been quoted earlier, or Section 5 of the Constitution, which makes the basis of unconstitutionality justifiability of the law in a society with proper respect for the rights of the individual. This is an area in which disagreements will be many. While it is my view that the section would have provided more effective protection to the citizens' rights had it laid down a speedy method of appeal to an objective third party, such as magistrate or an independent tribunal, I cannot say that this omission makes the section so seriously defective that it can be said to have been shown to be unjustifiable. The fourth criticism, that the law is prohibitory, not regulatory, appears to be based largely on the approach of certain justices in the United States, the Supreme Court. And he then goes on to discuss that, and he says, but the United States Supreme Court is not a proper comparator for this type of case under Section 13. And he makes that point on page 3039. Such a robust approach, as adopted by the United States Supreme Court, is not open to us in these courts, because, as I've indicated, the Constitution gives to the Parliament the power to override the fundamental rights. And all the courts can do is decide whether, in doing so, they have gone so far as to endanger the very structure of a society dedicated to the respect for the rights of the individual. A method of regulation not substantially dissimilar has received the blessing of the Privy Council in Francis and so forth. Now, my lords, of course, one always has to go back to the words of Section 13. I accept that. But I submit this is a useful example of how the court should approach the matter. And here, the judge is saying, well, thinking about it, Parliament could have done rather better. They could have had the right of appeal against the Commissioner of Police's decision not to allow public march to go ahead. That would have been better. But that doesn't of itself make this act not capable of reasonable justification. And in my submission, the ultimate test is one has to look and remember one point in particular. Acts are passed as general laws for the entirety of the population. You can always probably say, well, you didn't consider this possibility, you didn't consider that possibility. In my submission, that may well be the case. But that is not of itself enough to make the act, using one phrase, seriously defective, or, using another, incapable or not capable of reasonable justification. And I say this decision is probably the most useful because it gives them, it has a sort of clear exposition of how the judge approached the matter in that case, and also the reference to the Supreme Court of India's decision, I submit, is also a helpful one, because it doesn't get too tied down in questions of proportionality, objectives and things like that, which, in my submission, are not really very helpful when it comes to a simple question, is it reasonably justifiable? Has it been shown not to be reasonably justifiable? My lords, the other decision which I wanted to take you to is, briefly, is Privy Council's decision, which is at page tab 42 of the bundle, and therefore at page 2704, the rent restriction case. And this is, in my submission, useful, again, as an example generally, as to how, in this case, the Privy Council went about deciding whether or not an act which restricted a landlord's right to increase rent was justifiable or shown not to be justifiable. And one could pick it up in the judgment of Lord Templeman, page 2705. at D. The Act of 1981 was passed by the requisite majority and duly contained a declaration that it was to take effect even though inconsistent with sections 4 and 5 of the Constitution. The Act of 1981 interferes with the right of the landlord to the enjoyment of property by depriving him of $350 a month, which he was enjoying by way of rent in 1981, pursuant to a contract of letting freely and lawfully negotiated. The landlord submits that this interference was not reasonably justifiable in a society that has a proper respect for the rights and freedoms. The Act of 1981 is therefore, according to the landlord, invalid under the Constitution, because it wasn't passed, notwithstanding it was passed in the correct manner. Lord Templeman then goes on to say, at F, statutory rent restrictions have long been a feature of many societies, which maintain proper respect. The legislature of such a society considers that it is reasonably justifiable to limit the income which a landlord derives from his investment in order to limit the rent. Rent restrictions are justified by the need to prevent a landlord exploiting a shortage of housing accommodation. This justification is not universally approved. Some political parties believe that society should not interfere with freedom of contract and so forth. And then Lord Templeman goes on to deal with a particular submission made by Dr. Fenton Ramsay, the criticism being that there was no machinery to enable an independent tribunal to increase rents in line with inflation. And then Lord Templeman goes on to say, well, that doesn't make it not reasonably justifiable. But again, what I wish to emphasize you get from this case is, first of all, it's a relatively simple approach. You look at everything, but you also take into account different people have different views on this. Now, I accept in this case, Lord Templeman refers to other jurisdictions. He says, well, it's a perfectly normal thing in other jurisdictions for there to be rent restrictions. My learned friends, of course, say, well, Trinidad is the only one who's got this, or had this in 1994, this complete prohibition. My lords, I accept that one factor that one might take into account would be, what about other countries? Is this something that is done everywhere? That would obviously help a law get by, because you'd say, well, it's in accordance with understood norms. But even if it is the case that you are the only one who's got a law of this severity, it does certainly not follow that that law is not reasonably justifiable. Because, of course, these laws are drawn up for particular countries, and in Trinidad, the one thing that is absolutely clear is that there was, in 1994, a very serious crime problem indeed, and outrage at the fact, as it seemed, that so many people who'd been granted bail were simply committing repeat offences on bail.
But not in murder cases.
No, obviously not. I say, forgive my saying, obviously not. Ex hypothesi not, because they weren't being granted bail. But my lords...
Well, that really is quite a central point on one view. On your presentation, the prior law before the Bail Act was that there may have been a window of opportunity, a jurisdiction to grant bail,
Yes.
but it was almost never done.
It seems never done.
In fact, it was never done. So, against that background, what is the public interest that is said to make a complete ban reasonably justifiable? I mean, what is the mischief that required a complete ban on bail in cases of murder?
Well, my lords, it would be the same as the mischief. In other cases, my lords, I agree, it's often said there are many different types of cases of murder. My lords, one has to be careful about saying that in the context of Trinidad and Tobago. Maybe there are some domestic murders, but an awful lot of them, I can say this only from experience, in the cases that reached the Privy Council were indeed robberies gone wrong, yes, violent crimes.
Yes, I'm aware of the homicide rate and how different it is from certain other jurisdictions, and there are robberies and there's gang killings. I'm aware of that, but yes, at the end of the day, that doesn't really address the point I'm making, which is, if there was a very limited discretion because it was bound by custom and principle, what was the public end which might be reasonably justifiable of creating an outright ban?
Well, my lords, I think it's probably fair to say that everyone assumed there was already an outright ban. And that is, I'm going to take you to some of the material. There appears to be little doubt that the common assumption at the time was there is an outright ban.
But assuming that there wasn't an outright ban,
Yes.
I was wondering what the answer to Lord Hodges' point was.
Well, my lords, if one has to put oneself in the shoes of the members of Parliament of Trinidad and Tobago in 1994. There is a very serious rise in incident and violent crime. And many people who have not done such a serious crime as murder have committed. There's a very serious problem with people committing crime while on bail. That if that is the case, it might be thought to be rather, at least one interpretation might be thought to be rather counterintuitive to say, well, although we're going to restrict bail for all these other offences, what we are going to do is to open up the possibility of bail for murder. That, in my submission, would be, well, of course, can see the point, but in my submission, a reasonable approach of Parliament would be, we have a very serious crime problem, and it would be wrong, so to speak, to change the law of murder so as to provide for a discretion to grant bail when we have so much violent crime anyway.
But it could be a discretion which is very exercised very rarely.
Well, my lords,
And appropriately circumscribed.
It's a good point, and it's a point made by Lord Roger, I think, in Koirata. I mean, you could actually have a very tough requirements and so forth. My lords, I think that the actual answer is no one seems to have considered that at the time. I mean, in real life, that wasn't considered. But, my lord, if that being the case, I submit the board has to bear in mind this just wasn't, so to speak, on the agenda at all when Parliament met to discuss this law, nor had it been for 8 or 9 years and throughout all the discussions.
The legitimate aim of a law such as this is the prevention of crime and disorder. Crime and disorder was being prevented in any event because bail was not being granted in relation to people accused of murder.
Yes.
So what is the legitimate aim of this provision over and above the common law position?
Well, my lords, the legitimate aim would be, if I can put it, if I may be forgiven putting it the other way around, if Parliament had passed a law saying you can get bail in certain circumstances, then they may have been very concerned that the courts would too readily grant bail. In other words, a mistrust of the courts. And, my lords, that is undoubtedly one of the features which one notices. I'm not saying they mistrusted the Privy Council, but there was a concern, that, and this was the whole point of the Act, a concern that bail was too easily being granted in crimes of violence and drug traffic and so on. Hence the drive to restrict the court's jurisdiction. And my submission, it was consistent with that they maintain what was understood to be the common position in relation to murder, common law position or statutory position, rather than open it up. I fully take your lordship's point. One might say, well, why didn't they go down that path? The simple answer, as a matter of fact, is no one appears even to have thought of it. But then my other answer is it's not actually totally unreasonable or unjustifiable for them to maintain what they understood the law to be at that time, there being no suggestion that the law was operating unfairly in relation to murder cases. The law, as understood, was operating unfairly. So it was justifiable to keep the law in the same state as they believed it already to be. However mistakenly that's the case.
I think you've conceded that it was a mistaken belief as to what the law was.
Well, it appears to have been mistaken only in relation to what you might call a discretion, the existence of a discretion which was never in fact exercised. And no doubt would never have been exercised in any of the cases that actually had come before the courts in Trinidad in cases of murder. It is very striking. No one has come forward and said, well, you know, this operated terribly harshly in this case, or this domestic abuse case or whatever. No one did. And, my lords, I submit, that's why I say one has to look at things so much through the eyes of those sitting in Parliament in 1994. And what were the real concerns? One could easily see now you'd have the Mercy killing case. Someone might pipe up with that, and no doubt that would cause a lot of debate, or indeed the problems of wife beating and so forth. Then Parliament might have said, well, perhaps we should have some special exception, strictly circumscribed. But no one did. Now, my lords, you apprehend the argument against me, well, that doesn't make the law justifiable. They should have thought about it. My answer to that is, well, if no one is thinking about these things at the time, these are not public concerns at all at the time, and Parliament is passing a general law for the good of the country, it is justifiable that it passes the law in accordance with, if I can call it this way, the real concerns of people at the time, rather than more, as would then have seemed, abstract propositions which a lawyer could put forward. That is why I wish to emphasise this point about reasonably justifiable as opposed to justified. You might say, well, that shows the weakness of my case, which I say, no, it shows the deference which must be shown to Parliament in 1994. My lords,
I can appreciate the argument that Section 13 does require a considerable deference to be shown to the democratic legislature, because it is a provision that envisages the abrogation of fundamental rights, and the legislature takes the step with its eyes open.
Yes.
But even granting a wide range of appreciation to the legislature, if the measure has been taken on a misconceived perception of what the law was, and if there wasn't a need for this further restriction in order to avoid crime and disorder, I come back to the question, how can one say it's reasonably justifiable?
Well, my lords, you have my answer. Because the measure of reasonable justification is to be looked at as against the concerns being expressed at the time and the real position at the time.
The real position being?
The real position being that bail wasn't being granted in cases of murder, and no one at all saw any problem, because it was thought that it couldn't be. No one saw any problem with that at all. And there was no suggestion that it ought to be expanded. And that has been the case for a very long time indeed. And that, in my submission, is precisely because of the very high crime rate. And but Parliament does have to take into account public confidence in deciding which laws to pass. And, my lords, one can well imagine the potential outcry if someone had piped up and saying, well, you know what, I think I think the High Court should have some sort of residual discretion in extreme cases. My lords, that might not have commanded any confidence at all. The government might well have said, well, we think that would send out entirely the wrong message to the population. My lords, it's not my case that that one couldn't have drafted this law slightly better to include, if you like, the residual discretion. Clearly, if one thinks about it now, through our eyes in 2022, one would say, well, what was the harm in that? That's the case against me. Why not, as it were? But we say to that, you've got to look at the position as Parliament saw it in 1994. And that is the danger of this case now being heard so long after the passing of this law. It's difficult to get into the minds of those at the time and their way of thinking. And my simple submission is they're entitled to look at the realities as they are presented to them and reasonably presented to them, rather than by reference to abstract cases, or cases that would then have seemed abstract, but which now might seem rather more real to us. My lords, can I just take you to one? Sorry.
Yeah, I'm a bit concerned about this complete focus on what Parliament may be regarded as having perceived at the time.
Yes.
As opposed to the question, because they may have missed a whole aspect of an area that, had it been brought to their attention, they would clearly have dealt with. And in that sense, aren't we asking the question, were they mistaken to have missed the probability or possibility that there may be serious infringements of people's rights in extreme cases. Why are you saying it's a virtue that they didn't anticipate these problems?
I'm not saying it's a virtue, my lord, obviously.
Well, in one sense, you're saying we should show them more respect because that's what's happened, as opposed to thinking about what they ought to have been thinking about.
Well, I submit they were thinking about the right things. They were broadly right. I mean, the trouble is this case is coming to your lordships on a fine point of law. Is there a residual discretion, which was never in fact exercised? They don't assume for the moment that there is a residual discretion, which has never been exercised. Does that make the difference? Does it somehow invalidate their decision? I say not at all. It doesn't convert what would otherwise be a justifiable law into an unjustifiable one, because there's no reason in particular to think that had they considered this remote possibility, they would have made any difference to their decision. But more than that, I say one has to look at the
legislator wouldn't have thought that if they'd made a mistake about what the principles were, they would have come to the same conclusion.
Well, my lords, yes, my lords, I can't say whether they would have, one simply can't say. I mean, I'm not in a position to say, but all I can say is what their view was that there should be no bail for murder. That being the traditional view, and that also being consistent with the clamping down on the grant of bail in relation to other offences because of a perceived ease with which bail was being granted to violent offenders and then repeat offences taking place. My lords, I do accept this point. It could have been drafted so as to provide for that. It may have been better had it done so. That, in my submission, isn't the question. It's simply whether this law, as passed at the time, was reasonably justifiable. And the mere fact that they have passed it in an error of what you might call fine point of law does not make any difference to that. And my lords, I would like just to take you, briefly if I may, just to how many people considered the point. One does have to look at Parliament. It's not just Parliament who's come up with this. It's the judges, it's Chief Justices, it's everyone. Maybe everyone was acting under the same misapprehension, but I respect this as a misapprehension on a fine point of law rather than as to the realities as to how the law worked. My lords, if I can just go briefly to the background which led to the passing of the Act, and that is in Scene 9 at page 1592. I may just go back to that, because it gives some of the context.
Just before leaving that, I'm sorry for pursuing you.
Yes.
If they hadn't made the mistake, was there any justification for the law?
If they hadn't made the mistake?
Yes.
I found this on the web.
Sorry. I apologise.
I'm rather hoping that might give me the answer. If they hadn't made a mistake, I submit there's a justification for the law. I submit the law is justified bearing in mind the sort of concerns which everyone was thinking about at the time, rather than the remoter concerns which one might now have, which would have meant that the discretion, such as it was, should be retained. It comes down simply to that. I mean, one can easily see how the argument would be turned around. Well, what's the problem? Retaining a residual discretion, why not do that?
But it's not a residual discretion. It is a discretion exercised on judicial lines, and,
exactly.
And with a result that nobody was being granted bail for murder cases.
Yes. Well, in practice, we say, it would have been, no doubt, it would have been possible to pass a law which would, in fact, have catered for 100% of murder cases in any event. Highly restrictive conditions and so forth. But, my lords, that isn't the path Parliament took. My lords, can I just set out briefly what the history was which led to this Act? And you can pick it up, first of all, at page 1592. At para E. It's a well-known fact that serious crimes of violence, including murders, have been an almost everyday occurrence over the past 7 years. Most of these crimes have their roots in disturbing and alarming origins. In addition to all this, the court's been inundated over the years with many serious, complex, civil matters spanning all branches of the law, namely chancery and so on and so forth. Added to all this, the Court of Appeal has an awful lot of problems. My lords, that is the background. Very high rates of crime and a lot of murder, which has caused great problems. And of course, that creates a lot of problems for the courts as well, not an insubstantial point, as to how they deal with their business. The next point I wanted to go to is that the matter was considered, A, by the Law Commission in 1996, and then B, by the Constitutional Commission, and then C, by governments of different complexions from 1986 to 1986 onwards. And they all basically thought no bail for murder. A was the existing position, and B should continue to be the position. And my lords, briefly, if I can just give you the sequence. 2 bills in 1986 were drafted by the Law Commission. And the first of those, you can see, it's in a supplementary bundle, but I'm only taking to the bills, not to a cabinet minute. There's a supplementary bundle, and if you go to 3436, this is one of the bills that was drawn up, and apparently by the Law Commission. And the first is an explanatory note, which would always be attached to a bill. And you'll note it says under Clause 4. Clause 4 provides for the granting of murder in specified cases, except piracy, treason and murder, where a preliminary inquiry doesn't commence within 6 months. And then you go to Clause 4, and this is 3439.
This is the whose supplemental bundle? Is this
is our supplemental.
Your supplemental.
My Lord, the objection was taken to this because these bills are attached to a cabinet note, and the cabinet note wasn't in evidence. I'm not showing you the cabinet note, but these bills were made public, and they caused a lot of comment.
So it's the appellant's supplemental bundle?
Yes.
Right. Okay.
It should be. I've got an electronic bundle number for it.
It's in the main bundle.
Oh,
it's in the main bundle?
It's in the main bundle.
Ah,
yes.
Sorry, that's where I've gone. I was looking for a separate bundle.
Oh,
34.
Well, the original reference was 3436, which is just the explanatory note,
Yes.
which says what Clause 4 says. And then and then 3439
Thank you.
is the relevant section, which was then being proposed. This being drawn up by the Law Commission, except for the offences of piracy and so forth, treason and murder. And then you look at the first schedule, they're keeping the restriction on bail for murder, but adding lots of others. But the only point I want to get for the moment is in 1986, the Law Commission draws up an act, an entirely new act, which basically provides for murder being mandatory. Then another bill that was drawn up and also made public is at 3444, and this was essentially a bill which would alter various provisions of the Indictable Offences Act, a rather more complicated bill, but all I need to show you for the moment. Perhaps I'd just ask you at 3444, just note one point of the explanatory note. It's imperative to strike the right balance between, on the one hand, the principle that no one should be deprived of his liberty unless and until his guilt is proved, and on the other hand, the community interest that persons accused of criminal offences should not easily avoid trial, and that no one is released who cannot be released on bail with comparative safety. And then they go on to say that in the latter category fall offences precisely specified in section 29(1)(a). That is the view being taken at the time. And then the proposed amendment to section 29 is at 3471. I should show this to you. There could be a point against me in it. But 3471 is an amendment to section 29. For subsection 1, there shall be substituted the following: except as provided in section 34(1), bail shall not be granted to any person who is charged with an offence specified in the second schedule. Then a magistrate may grant bail in accordance with the Bail Act, and so forth. And then you go on to 3472 to see the proposed alteration to section 34. This is the High Court's jurisdiction. Where a person who has been committed for trial in respect of an offence referred to in 1A, conspiracy, murder, and so forth, is in custody awaiting such trial and is not brought to trial within 12 months after his arrest, the court or judge may, on the application of that person, grant him bail or with sureties. And then subsection 2, the court or judge may at any time on the petition of an accused person charged with an offence other than an offence in section 29 may grant bail. So in other words, this was a slightly softer version because although it prohibited the grant of bail, nonetheless it did provide that if you hadn't been brought to trial within the specified period, then there would be, then you could get bail. Now those two bills go out for public comment to the public, and they cause apparently uproar.
Where do we get that from?
Well, I'll come to that in a moment, if I may. But before I get to the passage, well, I can show you the uproar if you like. The uproar would be at page 3385, I think. Yes. You get this from Hansard in 1988. If you go to 3385, this is Hansard, I think, House of Representatives, and it looks as if there's a censure motion. And one of the things that comes up in this is the public reaction or criticisms of these, resulting from the publication of these two bills. And if you can pick it up at 3385, on the right-hand column, Mr. Speaker, two bills on bail were prepared by the independent authority, the Law Commission. Those are the ones I showed you, headed by Mr. Justice Ulrich Cross, two bills, and they were just proposals. I didn't take them to the Cabinet, which is very unusual, possibly unique, possibly the first time. What did I do? Instead of taking them to the Cabinet, all I asked Cabinet to do was to give me approval and cash to publish them in the daily papers. So every member of the public would have an opportunity to comment and tell me which one they preferred. And even if they preferred one, to tell me what amendments they'd like to make. And then the question is asked, well, had they been considered by Cabinet? And Mr. Richardson continues, basically saying he didn't, they weren't really discussed in Cabinet. But he continues over at the foot of the page, I want him to note that, and people who like to run the squeal to the press without reading properly, I repeat, two bills presenting different concepts were published for public comment. And then, Mr. Speaker, the Law Commission drafted these two bills. And then he carries on saying Cabinet agreed. But it just looks as if, as one reads the entirety of this, the whole debate is about a sort of general uproar created as a result of the publication of these two bills. That appears to be the gist of this.
But what was the aspect of the bills?
Restricting bail for all these other offences. It wasn't in relation to murder. There's no suggestion it was in relation to maintaining a position in relation to murder. It was extending the prohibition on bail to all these other offences. And my lords, I think you'll see they were pretty well absolute. But in any event, that was the problem. And that, my lords, in if I can just ask you to look at the...
I mean, how does that assist us then? I mean, if the outrage was in relation to the extension of a prohibition in relation to other crimes, it tells us nothing about the public's attitude in relation to the crime in question.
It doesn't tell you anything about what, my lords, what it does tell you is that there was no outrage in relation to the maintenance of the position in relation to murder. That is my point. It's put to the public, and no one is saying, hey, murderers or people accused of murder should be being granted bail. They're concerned about other things. But, my lords, it goes further than that. It's not just the public this is put to. The Constitution Commission considers the position. And perhaps the easiest way of taking it's set up in 1987, and you can find that in
The uproar in relation to the other offences was it wasn't necessary, presumably, to add them to the list, because the courts could deal with it under their discretion.
Well, I think, my lords, it might not have been put quite like that, but anyway, yes, there would have been uproar on the basis that you don't need to extend. It gives too much power to the police, my lords. I think it appears to be the nature of it, judging from later parliamentary debates.
Which brings me on to the rights in Article 5, are they fundamental rights? Section 5 of the Constitution.
Oh, certainly. Well, certainly, no doubt.
They're core principles.
My Lords, can I just, I'm not going to take all the material, but can I just take you to the Constitution Committee's attitude towards this? If you go to it's set up in 1987. It has a very distinguished membership, including Chief Justice Hayatali and Mr. Justice de la Bastide, who later became Chief Justice. They know what they're talking about. They know what they're doing. And one of the questions they specifically look into is the question of bail, because it's a contentious subject at the time. If I can just cut things short. We've got the 1987, as it were, note at 3429. And at 3432, you can see the questions they ask, and I'm afraid the answer, or one of their proposed answers, is an extra page we emailed over last night. My Lords, I don't want to take that for the moment, but could I ask you later to look at it? I just need to take you to the actual report they come up with in 1990. It's the quickest way of dealing with it. And that, one can see at 3426. And this is the report of the Commission, and begins at 3424, and it's talking generally about the Constitution and what should be done about the Constitution. But at 3426, you'll see they report in 1988, draft legislation was prepared and published, by which it was sought to introduce, and you'll see 1, 2, and 3, a substantial addition to the list of non-bailable offences.
Which paragraph are we?
107, sub 3.
Okay.
And you'll see they are taking for granted here a substantial addition to the list of non-bailable offences of murder, treason and piracy. Public comment was highly critical of the measure to remove the court's discretion to grant or refuse bail in such a large number of cases, and in the result, it wasn't proceeded with in Parliament. And then over the page, as has been stated above, the matter of bail is governed by common law principles, and so they advert to the discretion. Among them are the nature of the offence, treason, murder and piracy not being bailable offences. So that's the view being taken by the Constitution Commission in 1990, the character of the defendant and so forth. And then they continue at para 110, except in reference to the subsisting non-bailable offences, it would be both imprudent and irrational, in our opinion, to remove the court's discretion to grant or refuse bail for just cause. The answer to wrong decisions in granting or refusing bail is not to remove the discretion to do so, but to introduce updated machinery. But, my Lords, I do emphasise this. The Constitutional Commission, consisting of judges, is saying we think it's okay to maintain the status quo as understood in relation to murder. My Lords, in 1992, you then have Trinidad decided, which you've seen the references to their understanding of the post-committal position and, as far as pre-committal goes, time immemorial. So this is the whole background. Then you have the various debates in Parliament, which take place in 1994, when the bill that eventually gets passed as the 1994 Act is put to Parliament, obviously in different form initially. Can I just ask you to go, please, to page 3392. And this is when the bill is introduced by the then Attorney General, Mr. Sobian, 3392, on the 12th of August 1994. And in the opening passages of the bill, he sets out, of the Hansard 3393, he sets out the history. I don't propose to repeat all that, but it's obvious from this is a matter which has been troubling Parliament or the Law Commission and so forth for some considerable time, Constitutional Commission. You'll see at 3394, he says there was widespread comment from the public with the result that neither of those bills was laid before Parliament. Instead, they decided to have a further redraft. And then he notes, third paragraph down, if one looks at the Constitution Commission report, one would note that memoranda were received from over 40 organisations, over 128 individuals. In addition to those, a further 22 organisations also made representations to the Commission by attending its meetings, and a further 23 individuals. At the foot of the page, he recites item 107, which I just showed you from the Constitution Commission's report.
So which page are you on?
Page 3394 still, sorry. Near the foot of 3394.
3394. So this is the representative Sobion. It's not the Attorney General.
Yes, it's still the Attorney General. He is the Attorney General.
Oh, he is the Attorney General.
He's the Attorney General. This is the reason I'm taking this is he's introducing the bill and explaining what.
Oh yes, I see. Yes, of course he is. Yes.
And then item 107. He basically refers back to the Constitution Commission report. So that's been put before Parliament, and he refers to the passages I've taken, some of the passages I've taken you to.
Okay.
And then halfway down the page, the history therefore shows that over a period, in an instance of 5 years, the government was in a position to publish for public comment and so on. These two pieces of legislation received widespread public comment between the years 1980 and 90, and the attention of the High Attorney Constitutional Commission. In the process of evolution, we have now, 4 years later, based on experience, introduced a piece of legislation which seeks to modify the first attempt at bail legislation. And then at page 3396, he says, third paragraph down, the 1988 bills were substantially different from those of 1994. My Lord, I don't think, my Lord, one gets much more out of that page. Just 3397, halfway down the page, or the third paragraph, he talks about the draft legislation of 1988, says it didn't have a proper philosophical base, but then he adds, we must understand as well that whilst the underlying principle behind the system of bail is that there is a judicial termination, our existing law recognises there are circumstances in which the judicial arrestment will be removed. I refer specifically to the instance of murder and treason where a person only has to be charged, not convicted, for those two offences. So it does appear that it's being presented to Parliament on the basis that there is no discretion. But on the other hand, and then the final paragraph from 3397. The suggestion has come that murder and treason were non-bailable because of the sentence, and he goes on to say there are other countries which make it discretionary, but that doesn't have to apply to us. So, my lords, they are conscious that you could have bail for murder and treason, but there's no one suggesting that should happen at all. My lords, there is another passage, and I'm conscious at the time, which I did want to take you to, which for some reason got lopped off from the extract here. But we did email over last night something which is referred to in paragraph 53, subparagraph 3 of our case, which shows the very high numbers of bail applications being made by people who'd been arrested for an offence which they had committed while on bail. And, my lords, the relevant paragraph is 53, subparagraph 3. It was about, and I think this was appeals to the High Court, it was about 40 to 50% in the last 4 years of applications for bail were being made by people who had allegedly committed crimes of violence while on bail. And that was the driver behind this legislation.
What was the outcome of their applications? When they tried to persuade a judge that they would comply with bail conditions on this occasion, whereas they hadn't on previous occasions.
My lord, it doesn't go into it. It just said, he just says, basically says the figures aren't complete, but this is what's going on. We have an enormous amount of bail applications made by people who are said to have committed a crime while on bail. And that was the concern. And, my lords, I submit one has to give very... Yes, my lords, we have it, I think I'm conscious of the time, but it's in paragraph 53.3 of our case. But the broad point is, never mind the precise figures, an awful lot
I think it's
applications being made.
53(1)B, I think.
53, subparagraph 3 of our case at 1289. We summarise it there, and unfortunately it is in the passage we've sent over last night. It got lopped off. It's at page 628 to 629 of Hansard. In the email we sent over last night.
Can I just ask you this?
Yes.
Do you think proportionality has got anything to do with the exercise we're engaged in?
Oh yes, must do. I would say it comes into it.
How does it fit in with the reasonable justification?
Well, my lords, if, in this sense, let's say something is totally disproportionate, it might be a bit difficult for me to say it's reasonably justifiable. but it's not a complete answer. It's just a tool. I think in Francis, the Court of Appeal in Trinidad said proportionality is a tool which you can use for the purpose of deciding what the position is. But we do say it would be wrong to adopt it as a pure test, because the test has been derived, I think, from De Freitas, the case from Antigua, I think, and also then the human rights law, where what the court is looking at is the reasonableness of a derogation from a fundamental right. The court is not involved in the different exercise of just ascertaining whether an admitted inconsistency with the fundamental right is reasonably justifiable or not. There is a difference, in other words.
Yes, you can't simply apply Bank Mellat in this context, because you're having to show a much higher degree of deference to the legislature in the context where they have knowingly exercised the constitutional power to derogate from a fundamental right.
Yes.
Yeah.
So I accept it comes into the equation. I mean, if it's completely disproportionate, let us say, and that was the case in Francis, broadly. Francis was a case about excessive of 25 years minimum sentence for, I can't remember whether it was drug trafficking, but that of more than a kilogram of a drug. But then examples are given showing, well, that's just what words I think you use were grotesque, could be grotesque. But my lords, if one asks whether one would say this is a grotesque law, one would say, well, no, they've overlooked something. It boils down to. But that's why I say that's not the test. My lords, I'm conscious of the time. I don't want to intrude too much on what Mr. Hussain is going to say. We make other points in our case. It appears, the one point I do want to emphasise, it appears that what the opposition at that time the UNC were objecting to was the extension of the prohibition of bail to other offences. And there is a particular passage, I think, which is at, and this is in the Senate, at 3416, where a UNC man says, well, we don't have any problem, in broad terms, he says, we don't have any problem with the restriction on bail for murder. Our concern is all these other offences it's being extended to. And then, my lords, you have the points I made in my opening. There was no complaint from the Law Association, no one. And my lords, the most striking thing, perhaps, is you might have thought there were a lot of Trinidad's a lot of lawyers and people who sometimes can be quite litigious. Not a soul thought that this law was somehow unjustifiable. It is, in my submission, something which gives you an insight into what, whether really it's unjustifiable in practice. My lords, can I just briefly then turn to the Court of Appeal's reasons for holding that this was not reasonably justifiable? My lords, we set out our case on this in fairly summary form. I don't propose to repeat anything there, but we set this out in paragraph 53, I think, on 53 to 60 is where we say why the Court of Appeal got it wrong, the basic reasons why the Court of Appeal got it wrong. And that, I think, is at 1289 to 1292. Can I just take you to certain passages where I say you can see where the Court of Appeal is going, we say wrong. And the first is at 756, 62. And, my lords, what I want to emphasise in this, I don't say the Court of Appeal was sort of totally wrong in all respects. What I do say is they got some things right, but then they muddled them up with things that are wrong. And that made it wrong. And the first passage, as I said, which I wanted to go to, is 756, paragraph 62. And I think at this point they are talking here in a passage where they are considering the relationship between the separation of powers doctrine and section 13. Because essentially what they say is we don't think the separation of powers doctrine provides a complete answer to this, but it does come into considering the section 13 question. And what they say in 62 is some time was spent during oral arguments on the question whether independently of the section 13 inquiry, the statute could be declared unconstitutional because its terms offended, quote, the separation of powers. For the purpose of the analysis in this case, I do not consider that to be a useful distinction. Section 13 scrutiny is a broad and compendious examination that takes into account both the specific provisions of the Constitution. My Lord, so far, I agree. Absolutely right. And then they continue, and the core principles that underpin what is sometimes referred to as its deep structure. I say, well, that just begs the question, what are these core principles? And that isn't in the Constitution. And the reason I say it's wrong is because the one thing that is authorised by the Constitution is an alteration in the fundamental rights, specifically an alteration in the law relating to removal of bail. That is contemplated, something that can happen. Therefore, to talk of core principles as if there is something that can't happen is wrong. The Constitution is, unlike most other constitutions, quite a fluid thing because of this 3/5 majority point. And the other reason I say that is Section 1 is not deeply entrenched. The democratic principle, unlike in the Mauritian case, can simply be removed by simple majority. So the inquiry in my submission is not to introduce the notion of core principles or core judicial functions in my submission is wrong in law. It's irrelevant to the inquiry. It may only come in the question of ultimately looking at everything, is it reasonably justifiable that the law's been passed?
So you say that the task is simply to look at sections 4 and 5 and ask if the derogation is reasonably justifiable?
Yep, that's it.
Yes.
But you have to understand that section 4 and 5 rights can be, and including the bail right, can be derogated from. In principle, it can be, subject, of course, to reasonable justifiability of that. Now.
Clearly
but
so, yes.
Just to say, effectively, well, this is a core principle, therefore it's not reasonably justifiable, is wrong. So we say that, we say that indicates, it's only a small part of the thing, but we say this notion of core principles and deep structure doesn't help the analysis at all, and it tends to, and did mislead the Court of Appeal with respect. Then paragraphs 64 to 71 have a discussion about Mollison and Hines and Koirati. And all this discussion is taking place in the context of reasonable justifiability under Section 13. And we say it's irrelevant. They shouldn't be thinking about this at the time. It may or may not be right, this discussion, but it's not relevant to what they had to look at. And then in 75...
So what's not relevant, sorry?
Well, we say the Court of Appeal is looking at the separation of powers doctrine as if it has any relevance to the Section 13 question. We say it has no relevance to it. Of itself, it has no relevance. It doesn't take you anywhere. You should simply be asking yourself, bearing in mind the powers granted by the Constitution to Parliament, is this a reasonably justifiable? Or has it been shown not to be reasonably justifiable? That way round. But core principles, separation of powers, none of this helps. And it tends to, and we say it did mislead the Court of Appeal. And one can see, perhaps in particular, paragraph 75, for instance, as an example, the Chief Justice says, I don't accept that an analysis of a statute's constitutionality based on separation of powers can be conducted in isolation from Section 13 analysis. So he sort of seems to say, well, you've got to put the two together. For one thing, separation of powers doesn't exist as an abstract or absolute principle. We agree with that. It exists for a purpose, that is the protection of individual rights and freedoms and the preservation of the rule of law. Well, any proper analysis must recognise that, giving concrete expression to the principle that actual provisions of a written constitution requires a balancing act between the various arms of the state and respective powers reserved to each to preserve the notion of a modern democratic state. My lords, this then is the sentence I say is where they go too far. That in turn requires recourse to Section 13 because respect for individual rights and freedoms is at the core of what it means to be a sovereign democratic state. Well, that may not be objectionable. Then they continue, otherwise there'll be no guideposts or guardrails when questions about instances of actual or potential overlap of powers have to be resolved. Where the removal of the power to exercise judicial discretion is involved, an overlap becomes an encroachment and therefore impermissible, precisely at the point when it unjustifiably compromises in protected rights. Now, my lords, I submit there is a degree of muddled thinking there. We say, well, of course, one has to consider reasonable justifiability. But this notion that you bring into it that there's some inviolable separation of powers which cannot be altered is just not right. And the point becomes clearer at paragraph 82, point of this analysis, this is after discussing separation of powers, is that simply to say that reposing sentencing powers in the Executive Parliament breaches the separation of powers means it trespasses on a core judicial function, has limited explanatory power. It begs the question of why it is regarded as a core judicial function in the first place. The answer is it is necessary to protect fundamental rights and freedoms. And that's why there's a declaration and so on. Put another way, the nature and extent of the fundamental rights, as well as the boundaries of separation of legislative and judicial powers, are further defined in Section 5. That is an example of how the separation of powers is built into the structure of the Constitution. Conceptually, therefore, it's impossible to delink the boundaries of separation from proper respect for the individual rights and freedoms. Now, my lords, we say, of course, part of this is right, but this separation of powers point is given far too much importance. It doesn't, in my submission, have anything to do with Section 13. The only question is reasonable justifiability, and is it all right that was Parliament entitled, in the circumstances, to take this decision?
The separation of powers is just another way of articulating Section 5 to subparagraph H of the Constitution.
Well, not necessarily. In my submission, it could be. In one sense it is, but in my submission, it doesn't help the analysis at all to say we must remember the separation of powers, because the one thing that is authorised is a shift in the separation, or a shift in the division of powers, as long as it's reasonably justified. And that, in my submission, is the point the Court of Appeal overlooks. My lords, one can pick it up at paragraph 89. Page 767. And this is where the Court of Appeal gives its final answer. Turning now to answer the specific questions posed by this appeal, there are several considerations that influence my eventual conclusion. First, judges of the Supreme Court have always possessed the power to grant bail in cases of murder. Well, my lords, yes, but we say that has nothing to do with the reasonable justifiability point. Second, Section 5, that just goes to the point of inconsistency. Second, Section 5 of the Bail Act clearly derogates from fundamental rights and freedoms. Ditto, same point. That goes to the inconsistency point, not the justifiability point. Thirdly, it removes what, under the doctrine or principle of separation of powers, must be regarded as a core judicial power and discretion from the remit of the judiciary. Well, it undoubtedly does remove something from the remit of the judiciary, but it doesn't help to say that this is somehow contravening a core principle or the separation of powers, because the Constitution provides for just such a thing to happen, subject to reasonable justifiability. Fourthly, while there may be, and I emphasise the word may be, it's a terrible understatement, while there may be legitimate public policy concerns with respect to a rise in the instance of violent crime and the risk to public safety posed by repeat offenders, that must be juxtaposed against the presumption of innocence enjoyed before trial. We says that is a very considerable understatement of the problems Parliament is facing. And one of the things one's got to remember is Parliament is dealing with a crime wave. And just to and that's what is concerning them, and has been concerning them for a very long time. To say this, one might think one was in England. Well, no doubt there is crime, but it's not on the level of Trinidad and Tobago. And then, finally, there's nothing to suggest that having regard to the way in which courts have historically exercised the power to grant or refuse bail in murder, any statutory restrictions are necessary. Well, the trouble with that is that no one has ever suggested that people were applying for bail. It was never been considered. It's a non-point. The courts are perfectly capable of protecting the public interest. Well, my lords, that is exactly what Parliament said, or rather, obviously, rather doubts. That's the problem.
But I mean, the final point there, it might be the nub of the matter at that point, the judge is addressing the reasonable justifiability, and he is saying that, having regard to the way the courts have exercised their power to grant bail in cases of murder, there is no need for this complete prohibition.
That's the court's view. That's his view. Parliament's view was obviously the opposite. That is the problem in the case.
But you agree before us that they didn't grant bail.
They didn't grant bail, but Parliament
agree with the judge.
But Parliament wasn't considering the question against a background in relation to murder. of bail being granted too readily, because obviously it wasn't being granted. Parliament was considering this Bail Act against the background of bail being granted too readily in other violent crimes.
But it comes back to the point, how can you reasonably justify something that, on a proper understanding of the law, isn't needed?
Sorry, how can you reasonably justify?
Reasonably justify something which, on a proper understanding of the law, isn't needed. That the proper understanding is that there was a principled and judicially determined discretion, which meant that almost never was bail granted for murder, but there was a power to grant bail. Against that, why was, what possible justification was there for a complete and outright ban on bail?
Well, my lords, because in reality at that time, cases didn't arise, but I've given you my answer before. Yeah. There was concern about crimes being committed by people who'd been given bail too easily by the court.
But they weren't murderers.
They were.
Or people accused of murder.
But my lords, I accept that. But a fortiori, it might be said the other way. You're telling me that we shouldn't be granting bail to robbers, but we should have a discretion or residual discretion to grant bail for people accused of murder. My lords, that's why I say considerable judicial restraint is needed, because the underlying premise of this Act is essentially we don't trust the courts. That's the point. They've been a bit too soft on bail. That's why you restrict bail in relation to a further sets of offences.
I find some difficulty in that broad statement when one of the examples you give is that applicants keep on applying for bail despite the fact they've committed crimes whilst on bail. And you are unable to tell me whether or not those bail applications are refused as day follows night.
Well, I can't tell you. I don't think it's actually said whether or not they were. But one imagines they were.
I mean, if in fact bail applications were being granted in such circumstances, 40% of applicants were successful, despite having committed crimes whilst on bail, then there might be a serious question.
Yes.
But just to broadly say we don't trust the judiciary is quite a sweeping statement.
Well, my lords, in one sense, it is inevitable in a law such as this that is the underlying thinking. Or at least we need to make sure the judges tighten up very considerably in the exercise of their discretion. I don't think I can take it any further. You have my answer. The question is not, was it justified? Is it capable of justification given what all the material before Parliament at the time and the actual concerns that people had at the time? And we say the Court of Appeals simply don't deal with that. I've given you my individual criticisms. And I do suggest that you must bear in mind, rather as Justice Telford George has said, judicial restraint, because this is not an easy, I appreciate, I'm trying to tell the court that this law passed by members of Parliament essentially proceeds on the premise that they don't totally trust the courts in relation to bail. That is the justification for it, to which any court says, well, why can't you trust me? I'm the High Court. I'm sensible. Don't worry. I'm not going to go soft on these people. Don't worry. But, my lords, that is the decision Parliament made, and it's not, in my submission, one which is completely unjustifiable. One can see how they came to it, and there's a slight tendency to underestimate in real life how the violent and how the heinousness of the nature of murder as a crime. And that's what Parliament is looking at when it passes this law. And it's looking at the bigger picture rather than what you might call the theoretical picture, which undoubtedly can emerge and could have been put but wasn't put. So, Lords, that's what I say about Section 13. You have the gist of it. I've said it enough times. And I don't think I can it's not going to get any better. Mr. Hussain, I think we'll be able to deal in 10 minutes on our separation of powers point. My Lord, can I just say simply this? If I'm right about reasonable justifiability, the separation of powers point evaporates. It's very difficult to see how it can be, on the one hand, reasonably justifiable, but but inconsistent with the notion of a democratic state. And that can't be right. If I'm wrong on reasonable justifiability, and if and to the extent I'm wrong, again, it's very difficult to see what is added by the sovereign democratic state point. That's the simple point. But we say the underlying point very dangerous to look at cases from other jurisdictions which are not founded on Section 13. It's really as simple as that. But other jurisdictions do allow for changes in the Constitution itself by 2/3, 3/4 majorities. And that way you can get rid of a fundamental rights base. Trinidad allows for this specifically on a 3/5 majority, but you keep the rights in place. That's what's so unusual about this Constitution.
The Section 13 regime is unique, I think, to Trinidad.
My Lord, as far as I'm aware, it is unique.
Yes.
There's nothing unique. My Lord, those are my submission. Oh, as far as the relief is concerned, my Lord, you have my submission.
We have your submissions in writing. Yes.
Okay, thank you.
Yes. Mr. Knox, thank you very much. Mr. Hussain.
Why didn't you take my place?
Thank you very much, my lords. Let me just add a few comments in respect of the points my learned leader has made. And it has to do with how do you position a Section 13 override legislation in the context of things. Now, the rights in 4 and 5 are not absolute rights, so therefore the courts may from time to time be asked to apply the proportionality principle in determining whether that particular law passes muster or not. Now, when you go to Section 13, it is my respectful submission, it has to be approached from the following perspective. First of all, the presumption of constitutionality, as is mentioned in Surat. Secondly, an enhanced presumption of constitutionality because of the fact that the text of the bill and the act puts on notice the legislature what the act is about, and there's a requirement of a certificate that has to be produced. Secondly, because of the 3/5 majority. Fourthly, because of the fact that the act itself has an additional layer of protection, and that is whether it is reasonably justifiable or not. Now, it is my submission that because of the fact that the act comes into force, as soon as it is passed, it is assumed to be reasonably justifiable, and therefore it's up to an applicant who is challenging the act to prove it is not reasonably justifiable, that evidence has to be brought in respect of that. And that can be done in respect of evidence by affidavit, or as in the case of Francis, the court can analyze the act and see whether it is not reasonably justifiable. But the point about it is that it is for the applicant to prove that. The third point, my lord, is the issue of the margin of appreciation. And the short point is the separation of powers is a principle on which is widely discussed in the cases in starting with Hines, and it apportions to the legislature its own province of authority as it does in respect of the judiciary. So it is there not only to protect the judiciary, it is there to protect the legislature and the executive. And more often than not, the difference is between the legislature and the judiciary in respect of if the legislature is overreached. Now, that point is important in the context of Section 13, because what we have in Section 13 is a constitutionally authorized methodology by which the Constitution permits the legislature to override Sections 4 and 5, to presume the law is reasonably justifiable, to apply an enhanced margin of appreciation, to deal with the issue of deference, and place the onus on the respondent, on the applicant, to show it is not reasonably justifiable. And they're acting within the realm of the authority ascribed to them by the Constitution. So the section is unique in that sense, and therefore it's different. It's markedly different from a law which seeks to deal with breaches of sections 4 and 5 of the Constitution. Now, my Lord's man asked the question, what tests do you apply in respect of a breach that has that is alleged in respect of something that is not reasonably justifiable? Now, I don't think the proportionality test is adequate. I adopt Francis. It has to be disproportionate, but something way above that has to be developed. And this is why my learned leader developed the principle of justifiability, because it ties in with the separation of powers. It ties in with the fact that the section itself speaks about justifiability. So it places upon the court the task of developing a test against a background where the Bank-Mellard, the Freitas test is settled in respect of proportionality otherwise, as in Francis. And it now says, I am not developing a test. The court now has to determine that against the background of the separation of powers, against the background of the deference to the legislature, and against the background of the unique framework within which Section 13 is placed in the Constitution. Now, in that kind of setting, it is my respectful submission that attention has to be paid to the boundaries that exist between the legislature and the judiciary. It is for the legislature to take the temperature, if I might use that term, of what are the social circumstances existing in the country. What is the crime situation? What is the geography? Trinidad is 5 miles away from Venezuela. What are the factors that would help us in defining a society that maintains a balance on the one hand between the rights embodied in 4 and 5, and which on the other hand would allow us in a constitutionally mandated framework to go and to abrogate those rights as the case may be. And that is, those are the factors which the courts will have to take into consideration in determining what test to be applied. It's not, respectfully, a test that can be settled on a micro-legal basis, because it has to be settled through the lens of the legislature operating in 1994 and viewing the situation as it is. If it is now that people remain in prison for an inordinately long time, that is not a factor which, before trial for murder, that's not a factor to be taken into consideration, because that is an operationalization problem that deals with the justice system. What we are looking here plainly is how it is, how the approach should be used, and whether it is in those circumstances the judiciary is allowed to intervene. Now, our case is not that the judiciary is not allowed to intervene. Our case is that the section authorizes a breach of 4 and 5. So the judiciary may not intervene if there's a breach of 4 and 5. It has to intervene in circumstances which go beyond 4 and 5. The fact that the provision in respect of bail authorizes the legislature, even on a simple majority, to breach that section for just cause is one indication of where you have to go. So if therefore legislation is passed restricting bail for just cause on a simple majority and an assessment by the judiciary, that legislation totally varies on the basis of proportionality. The fact that the legislature has said that it breaches 4 and 5 in the preamble to the legislation is not a factor which the court has to accept, because the question of whether there's a breach of 4 and 5 is a matter for the judiciary. The legislation may say so in the act, but that the starting point is the judiciary has to determine that there is no just cause, firstly, and secondly, that the legislature is not reasonably justifiable in a society that has the proper respects for the rights and freedoms of the individual. Now I go on to my second point, and the second point is that there's no provision, and absolutely no provision in the Constitution, which says that the separation of powers is a core judicial principle or that it is a fundamental right. Parliaments from time to time breach the separation of powers in various forms. It is a principle which could be attenuated, and it has to be judged in the context of either sections 4 or 5 breach, which goes to the issue of proportionality, or a section 13 breach. And 2 examples come to mind. The first example is the example of Surat, where the Parliament created an Equal Opportunities Commission. And the argument arose as to whether the Equal Opportunities Commission breached the separation of powers and breached sections 4 and 5. And the President, Lady Hill, said no. She says that you apply the proportionality test because it was passed by a simple majority. There was no Section 15 override, no Section 13 override. And therefore, in this case, because you maintained your constitutional access to the court, the creation of an Equal Opportunities Commission did not derogate from the separation of powers, or in fact did not breach any of the 4 and 5 provisions. And that's a case in which the act was passed by a simple majority. Another case which springs to mind is the case of Ferguson, in which Lord Sumption wrote the majority judgment. And that is a case where Parliament passed a law which says no trial shall take place, and they identified the circumstances in which no trial shall take place. That is an act that was passed by a special majority using the Section 13 procedure. Subsequently, very shortly thereafter, Parliament passed legislation repealing that section and restoring what was there before, because there were allegations made that it was designed to assist certain persons. The applicants came to court and said, Parliament can't do that. Parliament cannot indicate that no rights, no trial shall take place, amounted almost to a statutory amnesty. And then legislate again and reinstate what is the former law. The separation of powers issue came up again, and Lord Sumption wrote his judgment. And Lord Sumption said clearly in his judgment that the separation of powers is not a principle of law. From his judgment, you can see it, a separation of powers is not a principle of law, which is there for all times, which can't be diminished or reduced by proper parliamentary intervention. I'll give my lords the citation for that in a short while. I think I have it there. So here are 2 examples. A third example is where you prescribe a minimum mandatory penalty, provided it does not breach other provisions of the Constitution, as in Francis. That's perfectly permissible. That lies, the question of sentences lie within the province of the judiciary. But Parliament has entered into that arena, and Parliament, in its wisdom, took the position that it can properly legislate in respect of that. So, in my respectful submission, my lords, this issue of a core judicial principle is not something set in stone. Millard Hodge in Chandler, identified there's no need for me to go into it in any great detail. Electronic bundle 2234, Millard dealt with the separation of powers as being a principle of interpretation, but provides no basis independent for the Constitution for invalidating legislation. Lord Sumption dealt with it at 2365 to 2409, particularly at Electronic Bundle 2329, and he described it as being a qualified right. One of the fundamental principles of the Constitution is the qualified separation of powers. It is qualified because the Westminster model has never required an absolute institutional separation between the 3 branches of the state. But relations between them are subject to restrictions on the use of its constitutional powers by one branch in the manner which interferes with the exercise of these powers by others. So Parliament cannot interfere. That's a 2329. So first of all, it's an interpretation principle from Lord Hodge's statements in Chandler 2324. Secondly, it's a qualified principle. Thirdly, it is not a principle that is a fundamental right. Fourthly, it is an interpretation principle. Fifthly, I think as Lord Hoffman said in Matthews at Electronic Bundle 2612, it's not an overriding supra-constitutional principle, but a description of how the powers under a real constitution are divided. So, therefore, from that we tease the proposition that the Parliament can diminish, provided it complies with the modalities prescribed by the law, certificate, etc., and reduce the extent of the separation of powers principle. The other point that touches on that is that there is no preeminence of any provision of the Constitution from each other. So Section 13 doesn't stand out as a sore thumb. Sections 1 to Sections 14, in fact, all the sections have to be read collectively. That's a simple try point, but I make it again for mostly my benefit, to appreciate the fact that Section 13 has to be read in the context of Section 1, and it has to be read in the context of Sections 4 and 5. And what is engaged here is a permissible abrogation of 4 and 5. And it is our respectful view, not that the courts can't review it. Of course the courts can review it. But when the courts are reviewing it, the courts can't place itself in the position of Parliament, which is seized of the policy considerations of why it enacted that particular piece of legislation, and returned in 1994 and said, you got it wrong. It should not be done in this kind of way. This is how you should have done it, as the case may be. If it is that Parliament wanted to make the position very, very clear, and wanted to make clear the fact that there will be no murder, no bail for murder persons, and that we are going to restrict the rights of bail in respect of other persons, either by a sunset clause or otherwise a matter for Parliament. On 11 occasions, the 1994 Act has been amended. On 11 occasions. And not in one single occasion have the Parliament saw it fit to review the position in Section 5 and the first schedule, because it assumed throughout this period of time, and not a single dissent, not a sound, not a trumpet heard in respect of the fact that you should now remove the non-bailability of persons who are charged with murder. Now, I say this because that person is left not without redress. Because if we look at, for example, the case of Pratt and Morgan, the savings provision said it's a mandatory death penalty, yet the courts were able to enter into the fray and said the facts of this case are such that 5 years in prison without the sentence being carried out is enough for the courts to intervene to review the executive action and to determine that the death penalty should be commuted. So the absence or presence of a law, in this case in respect of non-eligibility for bail for murder, doesn't just entitle the courts from entering on the basis of due process, on the basis of cruel and unusual treatment and punishment. That is part of the Constitution as well, Section 14. Section 14 is worded very, very broadly. Make such orders, issue such writs, and give such directions as you see fit. So it creates a template for the court to fashion unique remedies in the determination of situations where there's an absolute compulsion, that is death for murder or no bail for murder, and to determine whether the peculiar circumstances of the case merit an intervention by the court, as the case may be. Now, returning thirdly to my separation of powers issue.
Well, the appellants must be aware that they are eating into their reply time.
Oh, I see, okay. Well, I'm told that we go to 4 o'clock, I don't know.
No, 3:30.
3:30, okay.
So you're eating into your reply time now.
Well, my Lord, I'll just spend 5 minutes more. And the short point is this. The short point is that the allegation is that Section 1, which they say entitles them to review the legislation on the basis of the separation of powers, is new and unique. And our submission is this, that the court held in Chandler, that notwithstanding the fact that it is a safe law, the separation of powers is not applicable, and Chandler is there. And similarly, my lord, whatever the source of the separation of powers, whether it is Section 1, whether it's Sections 3 and 4, whether it's inherent in the Constitution, it is not a fundamental principle that can be used to independently, on its own, stand as a ground on which the challenge or which the...
I think you're pushing at an open door in that regard. I mean, an enlarged board has held in Chandler that it is it is not an independent ground.
Thank you very much for the opportunity, madam.
Thank you.
Yeah.
Thank you very much. Yes.
My Lord. My Lord, perhaps I can start by picking up some of the points made today. I have to say that it's a rather startling submission to listen to hear my learned friend say that the law prohibiting bail in the case of murder and other offenses was born out of a mistrust by the Parliament of the Republic of Trinidad and Tobago for its own judiciary. And I want to say, for the record, I take a little umbrage at that submission and that statement because the fact that there may be public concern about the way courts may decide cases and perhaps applications for bail from time to time, not just in Trinidad and Tobago, but I dare say in any country, because the court is not there to, as a populist institution, but to administer justice according to the law. And therefore, insofar as there might be some public concern, to elevate that and seek to equate it with a general state proposition that there is a mistrust on the part of the legislative arm of the state towards the judicial arm of the state in the Republic of Trinidad and Tobago, such that that justifies an encroachment on the jurisdiction of a court of law, is a rather alarming and I dare say dangerous statement for the rule of law. If Parliament mistrusts the judiciary, and that is a reasonable justification for taking away its jurisdiction on the question of the grant of bail for murder, I ask the question, well, where does one draw the line? Today it's murder, tomorrow it might be car theft and larceny and petty crimes. Why not remove Section 13 altogether? The short point is, my lord, I think the submission is unsubstantiated. It is unjustified, no pun intended. And I think that it is one that should hold no sway with the board. At most, what you may find is an articulation of a general concern on the part of some members of the public about the way cases may be decided. And I say cases, not just applications for bail. But I think my Lord Stevens hit the nail on the head when he asked for the statistics. As you will hear from my learned friend, Mr. Mendes, for the Law Association, when the application for the stay in this matter was made, and I don't know if it was heard by 3 members, 1 member, or all members of this panel, but both Mr. Mendes and I wrote to the state, and we asked for the statistics about 2 important things. 1, the rate of conviction, because the rate of conviction has a direct correlation with pretrial detention and the conditions within which that detention takes place. And the second was the number of bail applications, and most importantly, what was the outcome? And that information, that kind of empirical evidence and data can only come from the state, not the respondent. And to date, we are still waiting on that data. Now, my lords, the number of murder cases that are tried per annum are not that great. We have the judiciary's annual report, and we can make a copy available, but the complaint is that not many are being tried, not enough murder cases are being tried. And against the backdrop of that, one would have thought producing statistics to show the rate of conviction, and of course statistics when mere months ago people can apply for bail for murder for the first time, instead of seeking to create a sense of alarm, by saying there's an avalanche of applications by persons for bail, which is not in fact the case. The statistics, as far as we're aware, and there's an affidavit from Larry Williams, who is a senior criminal defense lawyer in Trinidad, and as far as we're aware, only 3 applications for bail have been granted. And of those 3, one of the persons remain in prison because he has not been able to meet the conditions, and I do not know the status of the other 2. But if
the applications for bail, by what sort of accused person? What's the crime of which they?
Murder. No,
this is 3 applications for bail for murder.
Yes, my lord. Yes, sorry, beg your pardon. This is since the Court of Appeal's judgment. Because in the Court of Appeal, when you look at the transcript at the hearing for the application for the stay or the suspension of the Court of Appeal's judgment, and you look at the evidence, it was a doom and gloom story that the state came with. That look, the system will collapse. It will be unable to withstand the sheer pressure and volume of applications for bail, and that will come cascading down on the judicial system, and that was the position that they put forward in support of their application for the stay in the court below. That position, I dare say, in a more diplomatic and tactful manner, was repeated in the application, in the renewed application before this board, but minus some very critical information that only they can produce. And that information is what prompted the question, the pertinent question for my Lord Stevens. Well, how many have been successful? Because that is the proof in the pudding with respect to the submission that there is good grounds and a justifiable basis for a mistrust of the judiciary, as the case may be. Yeah, as my Lord said, if it's 40%, is it 20%, or is it 5% or less?
Well, again, sorry, I may be missing something. When you say only 3 applications for bail for murder have been granted, is that in Trinidad and Tobago?
Yes.
And over what period?
Oh, it's since the Court of Appeal's judgment.
It's 22nd of February.
Yes, 22nd of February. And since the application for the stay was dismissed, because a short stay was granted to facilitate a written application being made. So during the period of the interregnum.
This is just the interregnum period.
Yes, that's right, Lord. During the period of the interregnum, we've had, I think the DPP said it was about 78 odd applications. But the short point is, I mean, only as far as I am aware, based on my own survey, and speaking to practitioners in Trinidad at the criminal bar, it's just less than 5. 3 granted, and even of those 3, one person, Dion King, who has been in remand for 22 years. Dion King, who has been on remand for 22 years, was granted bail and is still in prison because he couldn't meet the conditions. 2 other persons recently who were in prison for over 20 years on remand. They too were granted bail, but I don't know if they've been able to meet the conditions. But that is why we say that the period of detention and the conditions to which persons on remand are subjected, we say that those are relevant considerations in analyzing whether the measure is proportionate and reasonably justifiable, not just in a society that has respect for human rights. That's not the wording. It is in a society that has proper respect for the rights of individuals. And the word proper there, I emphasize it because it is not that you can say that there is a proper respect for rights if it is that the judiciary in Trinidad and Tobago has been repeatedly saying that things are at such a stage that you can take judicial notice of the fact that the conditions in the prisons are subhuman, horrific, revolting, and similar adjectives. And that comes from the former Chief Justices, it comes from several senior High Court judges, many of whom are now elevated and sitting on the Court of Appeal. We have provided you with an appendix with the extracts on those cases, and we have sent those judgments to the other side. And perhaps I can deal with them now if you... if you'd like, my lord. I see my lord
No,
reaching for it.
deal with them at your own.
Oh, that's fine, man. Okay.
I mean,
Well,
you're really just opening your submission at this stage. So
yeah, that's right.
deal with them when you wish.
Yeah. So, my lord, so the short point, in this case, of course, in light of the belated concession, which I have to say took us by surprise this morning, which was teased out during the course of the exchange between the board and council, that in respect of, it was hinted, I suppose, but there was no express concession in the written case that was filed, that in respect of pre-committal, there is now no longer any challenge to the fact that the court had jurisdiction to grant bail pre-committal. So we must now train our thoughts, focus our thoughts on the question of whether there is a restriction post-committal. Now, my lord, that is a new argument which was not raised in the courts below. I'm prepared to meet it, of course, because it's an important case, but I do say for the record that this is a new argument that confronted us at this level for the first time. Be that as it may, my lord, in answering that question, perhaps I can just briefly take you through the legislative provisions in the short time that we have. My lord, in the bundle that you would have gotten just before lunch, the 1917 ordinance, because of its antiquity, it does not contain a table of contents. So we have put one for you, and the reason for that is to, at a glance, by just looking at the marginal notes in the table of contents, it gives you an idea of the fact that this ordinance dealt primarily with the jurisdiction of magistrates and justices in the context of preliminary inquiries. And I won't take you through it because I don't think it's necessary, but where the word court is used, because court is defined as Supreme Court or judge, and where the word court is used, it is used in the context of post-committal. And that immediately, there's a clear line of demarcation in the ordinance that supports the fact that this deals primarily with magistrates and their jurisdiction. So, for example, if I take you to Section 5, search warrants, Section 5, subsection 4. In subsection 4, it says that if under any warrant there is brought before any magistrate any forged banknote, paper, instrument, and writing, in the absence of a lawful excuse, is an indictable offense according to any enactment for the time being in force. The court, if such person is committed for trial, or if there is no committal trial, the magistrate may cause such thing to be destroyed. So, and throughout you will see that distinction where it uses court by reference to post-committal, the post-committal stage. Again at section 21, binding over to give evidence, at the trial of the accused person before the court. At section 23, discharge, committal for trial. That deals with the magistrate's powers admitting an accused person to bail if the offense in 23.4, if the offense charged is bailable in nature. But it tells us that insofar as the magistrate's jurisdiction go, any offense over which they have jurisdiction, they can certainly grant bail post-committal. And then we come to section 25, which there are three categories. 25(1)(a), if it's a misdemeanor, where you're entitled to bail, you shall be admitted to bail. B, where the accused person charged with a felony, not being treason, murder, or piracy, and the magistrate may, in his discretion, admit him to bail, discretionary. And C, a magistrate shall not admit to bail any person charged with treason, murder, or piracy, or twice previously convicted of felony, whether summarily or not. Now, 25 does not say that you can't get bail for the offense of murder. There is no such statement. It doesn't address the question, because what it deals with is the jurisdiction of magistrates and the three categories where you might be entitled to be admitted to bail. The magistrate has a discretion, and where there is no discretion whatsoever. And then we come to section 28, bail on committal for trial. And in bail on committal for trial, thereafter we come to section 30. Section 30, bailing of accused after committal. And we are told in section 30, if an accused person who is entitled to be admitted to bail, or if an accused person whom the magistrate has power to bail, and who in his opinion ought to be bailed, is committed to prison only because he does not, at the time of the committal or for trial, procure sufficient surety. It goes on to say he can get bail, and a certificate of his consent for the accused person being bailed shall state the amount. And in subsection 2, he shall admit him to bail. So clearly, even if he got bail and he couldn't make the bail, the magistrate still had a discretion post-committal in offences that fell under his jurisdiction to grant the bail. And then immediately after that section comes now section 31. And I think it's structurally, the fact that it is placed sequentially after that section is significant, because the section 30 dealt with bail in the context of post-committal proceedings in respect of offences over which the magistrate had jurisdiction. And section 31 says, the court or judge may at any time, and those four words, may at any time, is what we say undermines the submission that there was a distinction between pre and post-committal. Because the words may at any time on the petition of any accused person or such person, whether he has been committed for trial or not. So the words are clear and express, whether he has been committed for trial or not, to be admitted to bail, and the recognitions of bail, if the court so directs, be taken before any magistrate. We say those words could not be clearer. And the one thing, despite all the permutations that have occurred with all the amendments and renumbering through the Law Revision Commission and so on, this section has remained intact and remains good law today.
Section 34, is it? No.
Yes, it's been renumbered, yes. But this section has stood the test of time and has been retained throughout. And we say this is a section that gives the High Court judges the jurisdiction and power to grant bail, whether pre or post committal. We say further that it would be illogical if the power to grant bail exists even after conviction, pending the hearing and determination of an appeal, and there is no power to grant bail post committal. On the basis that after committal, because there's a prima facie case made out against you, that somehow justifies an interference with the presumption of innocence. If you can get bail after conviction, pending the hearing of an appeal, and the jurisdiction exists to do that, for sure, one would have thought that post-committal, because the threshold for committal is fairly low, and you may have different levels of judicial opinion as to how tenuous or weak the prosecution's case may be, depending on the circumstances. So, my Lord, that's what we say in relation to that. The next step is the 1925 legislation. Would that be a suitable time to adjourn and turn to 1925 tomorrow? It certainly would, my Lord. Thank you very much. Thank you very much. Much obliged. The board will adjourn.